Welcome. In this video, we're going to continue our broad overview of the course by looking at Chapter 3, the subjects of international economic law. We're going to start with the states being the key actors in the development of international economic law. Now, one of the first questions we have to deal with is the meaning of sovereignty in a globalized economy. In a formal sense, a state is sovereign if its acts are not subject to rules other than those of international law. As you can see from this quotation from Ian Brownlee's Public International Law, classic textbook of international law, the sovereignty and equality of states are part of a basic constitutional doctrine of international law. So international law governs a community that consists primarily of states, and states have a uniform legal personality. One of the important implications of this can be found in Article 2, Paragraph 1 of the United Nations Charter. The organization is based on the principle of the sovereign equality of all its members. Now, if you think about equality, we can distinguish between formal and actual equality. And the question is sovereign equality compatible with differentiation of international obligations according to the level of economic development? That is to say, is positive discrimination compatible with equality among nations? And is there a right to the adoption by developed countries of positive discrimination measures vis-à-vis developing countries? Now, this forms part of the claims made by developing countries in the context of the new international economic order. And you can find some vague language in the Charter of Economic Rights and Duties of States, General Assembly resolution, where it states that all states should respond to the generally recognized or mutually agreed development needs and objectives of developing countries, and then by promoting increased net flows of real resources to these developing countries, taking into account any obligations and commitments undertaken by the states concerned, so in order to reinforce the efforts of these developing countries to improve their development. In this slide, you can see an example set by the UN Millennium Development Goals in terms of the increase of official development assistance from developing countries to developed countries. Also, with regard to trade, as you can see, by 2014, almost 4/5 of the imports from developing to developed countries were actually admitted duty-free, and that was up from 65% in the year 2000. So this shows that there's a growing commitment to helping the developing countries, either through direct aid as well as through better access terms to the markets of developed countries. Now, when we think about economic sovereignty, there are a couple of texts by the UN General Assembly that are key to understanding how this concept is debated in international economic law. The first is the General Assembly Resolution 1803 from 1962. It's the resolution on full and permanent sovereignty over natural resources. And then the Charter of Economic Rights and Duties of States, General Assembly Resolution 3281, where it states that every state has and shall freely exercise full permanent sovereignty, including the possession, use, and disposal over all its wealth, natural resources, and economic activities. So sovereignty is here subjected to these two adjectives. Full, in the sense that it cannot be limited by other states' needs of access to such wealth, the example being fossil fuels, but you can think of other examples. And it has to be permanent in the sense that sovereignty can be exercised in any given moment in view of the national interest. So past obligations undertaken by a state do not limit the exercise of sovereignty over its wealth. This has a lot of meaning, particularly in the area of international investment, as we will see later in the course. An important concept also to take into account when we think of states as actors of international economic law is the concept of the reserved domain of domestic jurisdiction. As Professor Brownlee highlighted, one of the consequences of this principle of independence and equality of states is the duty on the part of other states to refrain from intervening in the internal or external affairs of other states. Now, there is no numerous clauses of reserved activities, so the scope of the reserved domain really depends on the development of international law. The more international law develops specific substantive provisions, the less reserved the domain will remain for domestic jurisdiction. As you can see here in Article 2, Paragraph 7 of the UN Charter, it's clearly established that the United Nations is not authorized to intervene in matters which are essentially within the domestic jurisdiction of any state, or require those members to submit such matters to settlement under the Charter. This principle, however, does not prejudice the application of enforcement measures under Chapter 7, which deals with international security and the role of the UN Security Council. Now, when we think of economic relations, we can raise the question, does it really make sense to talk of a reserved domain in this area? I give here one example. When you think of macroeconomic policies, states that are members of the International Monetary Fund are subject, as we will see in part 2 of our course, to multilateral supervision under Article 4 of the Articles of Agreement of the IMF, insofar as such macroeconomic policies may have an impact on exchange rate policies. Now, this means that IMF members cannot invoke a reserved domain regarding the analysis of such policies, although they are the ones that are responsible for defining and implementing such policies in accordance with their international obligations. We can think of the Euro area members that are subject to even more severe legal constraints on their ability to define and implement macroeconomic policies, but in this case under EU law, not international law. Another challenge to the idea of a reserved domain, something that would be the province only of states to regulate, are the global challenges that mankind faces today. We can think of some areas such as externalities, environment and public health are good examples of that show that the exercise of jurisdiction by each sovereign state does not sufficiently address transnational phenomena. So we have a number of problems here. On the one hand, you can have the simultaneous exercise of sovereignty that deprives national measures of their intended effect. In one sense, these measures adopted by state A, will deprive measures taken by state B of their intended effect, leading to either a race to the bottom or a race to the top. And you can think of areas such as environmental protection, but also other areas like regulating tax havens, where there is a tendency for states to compete through these tax havens. And in this case, the simultaneous exercise of sovereignty will nullify measures taken by other states. In other areas, you need coordination of sovereign powers if you are to ensure the provision of global public goods or to avoid coordination problems. An example of that is the so-called tragedy of the commons, which is taken from game theory in economics, and we will look at that in our classes. And then, finally, you may need new powers to be exercised in a common institutional settings. So some of these challenges pose such new challenges that states cannot, even by themselves or coordinating with other states, address these challenges. So they need to institutionalize their cooperation and create new powers that can then be exercised in common, particularly through international organizations. One approach that looks at sovereignty in a globalized economy is the so-called conflict of laws approach. Some authors propose that the coordination of national laws using conflict of laws principles could be an alternative to tackle global problems. This is the so-called private international law model because it really requires norms of conflict to decide which laws should apply to a given international problem. Here in our class, we're going to look at this in two relevant dimensions. The first is sovereign immunity and its exceptions, which basically means using domestic courts to deal with foreign conduct. As we will see there are a number of limitations for this approach. The other one is extraterritoriality, that is to say, to enforce domestic laws against facts that take place outside the forum state jurisdiction. Let's look first at sovereign immunity. The principle is one of jurisdictional immunity, using the Latin phrase in parem non habet jurisdictionem. This means that a state cannot judge another state. So sovereigns cannot exercise sovereignty over another sovereign. They cannot exercise jurisdiction because that would obviously imply that the second sovereign is not really sovereign because it would be dependent upon the jurisdiction of another sovereign. However, a sovereign may waive immunity and subject itself to the courts of another state, but it's a decision taken by that sovereign. Sovereign immunity has evolved to distinguish between so-called acts iure imperii, so acts where you have some form of exercise of state power, and acts iure gestionis, acts adopted in the normal course of business. Only the latter will be subject to foreign jurisdiction in accordance with the rules of the state of the forum. So acts iure imperii are generally considered to benefit from sovereign immunity. There is this restrictive approach to immunity, that is to say only acts iure imperii, that is now commonplace. As you can see, the US, the United Kingdom, the European Convention on State Immunity by the Council of Europe, and the UN Convention on Jurisdictional Immunities of States and Their Property, all these now adopt this restrictive approach to immunity. So only acts iure imperii are subject to this exception and thus cannot be judged before a foreign court. So State A cannot be prosecuted before the courts of State B, even when A's action is in breach of international law, and that is the general principle. So a foreign state cannot be sued or prosecuted before a domestic court. But can they resort to another state courts to enforce a legal claim? That depends on the so-called rules of locus standi, that is to say, whether the state of the forum, whether its legal rules admit that a state appears before its courts as a plaintiff. Now, the principle of accepting a foreign state as a plaintiff is generally accepted as a matter of comity. Comity are the accepted rules of mutual conduct as between state and state, which each state adopts in relation to other states and expects other states to adopt in relation to itself, as defined in the case Buck versus AG of 1965, a case by the US Supreme Court. There are limits to this privilege. And these limits are the non-enforcement of penal or revenue laws and the refusal to admit disputes between the plaintiff state and the state of the forum or a third state, the latter being obviously corollaries of the principle of sovereign equality. One of the cases we will look at in class that deals with sovereign immunity is the Pasquantino versus United States. In this case, the US government is prosecuting several US nationals for a federal crime. The facts involve the smuggling of alcoholic beverages from the US to Canada. Now, because of this smuggling operation, Canada lost tax revenues that were considered by the US law as money or property for the purposes of US federal criminal law. So the question is, does the case involve the enforcement of Canadian tax law before US courts? In the case, there was no doubt that Canada's financial interests were hurt by the action of these criminals under US law. The problem was whether this could be seen as a fraud case by just disregarding the fact that the revenues that Canada had lost were set by Canadian tax law. And so, in a sense, any compensation for these lost tax revenues would amount to being pretty much the same as if the United States was enforcing Canadian tax law from the defendants in the criminal case. Something that we will look at in our class. Now, the second dimension deals with extraterritoriality, and that is enforcing our own laws against conduct that takes place abroad. Now, the main distinction that we have to keep in mind is the distinction between so-called jurisdiction to prescribe, that is to say, the state's authority to make its laws applicable to certain persons or activities or a set of facts, and jurisdiction to enforce, a state's power to take executive action to enforce its laws, that is to say, to prosecute and punish acts that are contrary to its laws. In this slide, I've tried to present a synthesis of the applicable principles of general international law. So generally, jurisdiction is based on the concept of territoriality, the territorial principle. That is the main foundation for exercising both jurisdiction to prescribe as well as jurisdiction to enforce, although the latter, that is jurisdiction to enforce, has greater restraints on the exercise of extraterritorial jurisdiction. In fact, typically jurisdiction to enforce is strictly limited to the territory of the acting state. The territorial principle has two different concepts. Subjective territoriality deals with the exercise of jurisdiction by a state over an event which originates in its territory. Objective territoriality, on the other hand, deals with the exercise of jurisdiction by a state over an event that begins in another state but terminates or has its effects in the territory of the state that wants to apply its jurisdiction. Ultimately, this depends on whether or not there's a substantial and genuine connection between the subject matter and the state exercising jurisdiction. This is the principle that has emerged from state practice, one that is particularly well explained by Professor Brownlee in his textbook on public international law. As he noted, the scope and sufficiency of the grounds invoked for the exercise of jurisdiction really depends on a balance of the rights of different states. And this is particularly important in coordinating the exercise of state supervision over transnational economic activities. We will have the opportunity to look at a couple of examples taken from the so-called extraterritorial application of competition law. We now turn to international economic organizations, the second major type of subject of international economic law. Here you can find the definition by Professor Petersman of an international economic organization. As you can see, the basis for these economic organizations, for these international economic organizations, is an association of states. They typically are established by an agreement and tend to have a permanent set of organs with their own autonomous functions and powers, pursuing common economic objectives through cooperation among its members. An important point to take note right now is that each organization has its own legal order, and that legal order is valid only with regard to its members. In contrast, we may consider that given the UN's specific legal nature, that it has so-called objective legal personality, in the sense that its legal personality imposes itself not just on its members, but also on non-members of the UN. But the UN is really a special case, as we will see. In the UN system, we have a number of specialized global economic organizations. The so-called Bretton Woods sisters, because they were both created following the Bretton Woods Conference in 1944, the International Monetary Fund and the World Bank Group. The World Trade Organization, created by an agreement of 1994, the Marrakesh Agreement, the Marrakesh Treaty, and entered into force, began its activity in 1995. UNCTAD, which is not a formal international organization, it's the United Nations Conference on Trade and Development. And then we have a number of specialized agencies such as FAO, the WHO, the ILO, or International Labour Organization, BIS, or the Bank for International Settlements, IEA, International Energy Agency, etc., etc. There's a plethora of such specialized agencies. I just wanted to highlight some of the most important ones. Outside the system of the UN, we find countless other international economic organizations. Just to give a few examples, we have the OECD, the Organization for Economic Coordination and Development, that was initially created to manage the Marshall Fund aid to Europe, and that comprises mainly industrialized countries. So it's typically seen as the club of the more advanced industrialized economies in the world. Then we have a number of regional economic integration organizations. If we think of Europe, obviously the EU is one such organization, but you can also see EFTA, the European Free Trade Area, and there are other international economic organizations in other continents, in Asia, ASEAN, in the Americas, NAFTA, now to be replaced by a new agreement in the south part of the Americas, Mercosur, and the Andean Pact. Africa, we have WEMOA, CDAO or ECOWAS, and the Southern Africa Development Community. So there are a number of international economic organizations that specialize in this regional integration. As we're going to see, this also is quite relevant in the field of international trade in particular. Then, although not quite international organizations, we have a number of informal intergovernmental groups that are also key actors in international economic law. I just give you some examples here. The G7, the group formed by the finance ministers from the 7 large industrialized countries, the US, UK, France, Germany, Italy, Japan, and Canada. That was for a time the G8, that is the G7 plus the Russian Federation. This latter formation collapsed following the Russian aggression on the Ukraine, particularly the Crimean Peninsula. And so the G7 was brought back in the old configuration. The G20 is a more representative group of major economies, 19 states plus the European Union. It includes the G8 plus a number of countries from across the globe: South Africa, Mexico, Brazil, Argentina, China, South Korea, India, Indonesia, etc. So it comprises not just developed countries, but also a number of developing countries, particularly the ones that are currently more relevant in international economic affairs, such as China, for instance, or India or Brazil. There are a number of other informal groups that we will deal with in this course: the G10 within the context of the IMF, as well as the G24, also relevant in that context. And an important group for historical purposes was the G77, so-called non-aligned or third world countries. And this is a group, an informal group within the context of the UN. We now move to the topic of economic actors and international economic law. Now, the first question is whether these are actors or actual subjects of international economic law. As you will know from general international law, individuals and firms are not generally considered as subjects of international law. Now, as we will see briefly, this is changing with regard to emerging attempts to develop rules of international law that directly regulate some economic actors, in particular multinational corporations. And then the change in rules regarding the ability to directly challenge state conduct affecting private economic interests, particularly in the context of ICSID, the International Center for the Settlement of Investment Disputes, and also by allowing participation of private entities in state-to-state dispute settlement, something we will see in the context of the World Trade Organization. Now, the first attempt to regulate multinational corporations is something that goes back in time to the 1960s and 1970s. A multinational enterprise or multinational corporation is a corporation that is registered in more than one state, or one that has operations in more than one state. And you can think of examples that will very easily come to mind of these MNCs, multinational corporations. As I said, the attempts to regulate these through international law um, have already been attempted for several decades. One is the International Labour Organization, the Tripartite Declaration of Principles Governing Multinational Enterprises and Social Policy, now in its fifth edition of 2017. The UN Economic and Social Committee set up a commission on transnational corporations in 1974, and it was particularly active in the field of human rights and transnational corporations. The UNCTAD has adopted codes of conduct on restrictive trade practices and technology transfer. These are both acts of soft law. The Andean Pact has adopted a common code on investments. And finally, probably the most successful initiative so far, the OECD Guidelines for Multinational Enterprises. Its original text was adopted in 1976, and it has successive revisions, and current text in force is the 2011 revised text. And let's look at some of the characteristics of these OECD guidelines just to get a sense of what it means to regulate these multinational companies. Now, the definition of a multinational enterprise, as you can see, is companies or other entities established in more than one country. So the same idea we saw earlier. So they operate in more than one country, but they are so linked that they may coordinate their operation in various ways. The guidelines adopted by the OECD are addressed to all the entities within the multinational enterprise, that is to say, both the parent companies as well as local entities. Now, these guidelines are mere recommendations addressed by the governments to multinational enterprises, and textually they provide non-binding principles and standards for responsible business conduct in a global context that is consistent with applicable laws and international recognized standards. So in a sense, it tries to encapsulate these standards into a set of non-binding principles and standards that governments recommend to multinational enterprises. Now, its scope covers the conduct of multinational enterprises operating in and from adhering countries, but necessarily respecting the host state domestic law. So, Section 2 of the guidelines states that obeying domestic laws is the first obligation of enterprises. However, in countries where these laws and regulations conflict with principles and standards of the guidelines, enterprises should seek ways to honor such principles and standards to the full extent which does not place them in violation of domestic law. And you can see that there are very tricky issues here. You can think, for instance, of how a global firm like Google operates in some markets where there are a number of policies that restrict the freedom of citizens to have access to information. And you can think of the case of Google as it operates in China. Now, governments should not use these guidelines for protectionist purposes or to call into question comparative advantage. So this is not a way to force other states to adopt the same type of legislation that you find in the countries of origin of these multinational enterprises. So governments do have the right to prescribe conditions under which these multinational enterprises operate within their jurisdictions subject to international law. So that is the basic principle, that the state has the jurisdiction over its territory, and this comprises obviously any multinational enterprise operating within that jurisdiction. Now, where there's conflicting requirements, then governments are urged to cooperate in good faith. So the question then is brought back to the International Forum of government-to-government discussion. And the guidelines encourage governments to solve these conflicts through international dispute settlement mechanisms, including arbitration. In terms of the objectives to be pursued, as you can see, multinational enterprises should contribute to sustainable development. They should respect human rights, refrain from seeking or accepting special exemptions from human rights, environmental, public health, labor, and tax or other issues. They should support good governance rules, carry risk-based due diligence, abstain from improper involvement in local political activities. The 2011 revision added an important chapter on human rights, though the commentary indicates that this is the global standard of expected conduct independently of the ability and/or willingness of states to fulfill their human rights obligations. Some final notes on non-governmental organizations, or NGOs. These have been increasingly active in dispute settlement proceedings. One important consequence of the criticism on the workings of the WTO, particularly strong at the Seattle Ministerial Conference in 1999, has been a readiness to open the debate to participation of NGOs. Here in this picture, you can see a flag showing that democracy, an arrow with democracy going one way, the WTO going the other way, with the famous Seattle needle. This was part of the protests at the Seattle Ministerial Conference at the end of 1999. So these NGOs are now invited as observers to meetings of global international economic organizations, or they take part in side debates. But in the context of the WTO, they're also admitted to present observations in state-to-state dispute settlement as amicus curiae, which is Latin for the friend of the court for an intervention that is supposed to be unbiased, detached from the interests of the parties. And as we will see in the WTO, in the shrimps case, the US received some amicus curiae, received some submissions by NGOs, 3 groups of NGOs, and during the case, it attached to its submission these submissions from these NGOs. And the appellate body accepted the submissions as part of the US submission, thus indirectly recognizing access to these NGOs, to access of these NGOs to the dispute settlement procedure. Now, just to wrap up, there are a number of legitimacy issues regarding NGOs. The questions like how representative they are, how they're financed, and whether there are sufficient checks and balances on their increased lobbying power. Now, obviously, these criticisms do need to be contrasted with the lobbying power of multinationals, something which has been pointed out very often in past decades. Okay, and that's it for this presentation. The next video will deal with Chapter 4, which deals with sanctions and dispute settlement in international economic law.